Okay, if you guys can start posting any questions that you have. If you don't, then I'm going to get to some of the questions that we have in the email to get us started, okay? And try to make your questions somewhat specific. Give me a single question at a time so that we can address that. If you do make it compound, I might break it down. Last week, if you guys were here, we covered a lot of good material. We got into a doctrine that I remembered later was called the clean hands doctrine, and we were talking about situations where parents create conditions, or a parent might create a condition during the pendency of your lawsuit, whether it be just divorce, child custody, whatever it is that you guys are litigating over, and they'll create conditions to disadvantage you. They've been using that doctrine for a long, long time in contract law. They tend to not use anything that they can avoid in family law, as most of you know. But get familiar with that. I just posted it on my blog. There's lots and lots of cases that use it. Get familiar with it and talk to your lawyer to see if maybe they can integrate some arguments to get the judge to rule on whether or not they're going to allow conditions that were created during the pendency of the suit, because that's not really an accurate picture of what's going on, right? And I don't mean accurate picture as in, do they know your life? Do they know everything about it, everything about the child's life? What I'm talking about is an accurate picture of whether or not a parent is a danger or unfit for a child. So, you know, they're creating inflammatory conditions. They're stressing you out. They're making you worried. Some of them are even taking off with your children, closing bank accounts. So naturally, you're going to be responding to those things. I know sometimes you probably regret some of the responses that you have, but either way, it's human. And so there's a lot of dialogue around that, but you want to make sure that's out there and up front and that you address that. So we did talk a little bit about that last Thursday. We talked about that being one of the elephants in the room, that if you don't address that elephant in the room, let me get that blog post for you. If you don't address it, they're going to use it against you. And then maybe you're not going to get an opportunity to address it, because at some point in time, that judge has made up their mind, haven't they? And then they don't let you talk anymore. So you need to get it out there as soon as possible. If nothing else, to put it on the record. There's something else that I want to address before we get started in your questions. Let me give you the blog link so you guys can all go there and get that Clean Hands Doctrine quote that I just posted right before I started the webinar. It's really important. I think it's a very simple way of looking at the Clean Hands Doctrine. I think if you'll be able to understand how it maybe relates to you, even though it's not a divorce or child custody case that I got it from. Okay, so you guys don't have to go there now and look at it, but I'm going to tell you the name of it. It is Brown versus Lee, Minnesota Court of Appeals, 2015. So it's not a Supreme Court case from the United States Supreme Court. And if you're not in Minnesota and you're not in that appellate court, it's not going to be controlling for you. But again, what you're trying to do is understand some of these concepts so that you start making better choices and better decisions with your lawyer and in the court itself. So if you don't have a lawyer, understanding the way they might look at something or think about something will help you get the result that you want, because you will learn how to communicate to the court in a way that they can take appropriate action. Okay, doesn't mean they will. And that's the other thing that I wanted to address with you, is right before I came into this webinar, I was getting some emails. I won't mention any names. And I see your question there, Steve. I'll get to that. I won't mention any names, but you know, when someone emails me and says, I talked to a parent and they said they used your methods and they didn't work, no method always works all the time. The methods that we teach, by the way, are not just any method. It's not just materials that we created. What we are teaching is the foundation of your rights and the protection of those rights. So when somebody says that it didn't work, what does that mean exactly? And in this particular case, it means the judge didn't side with them. We tell everybody all the time that just because you go in there and you show the judge you learned your rights does not mean the judge is going to agree with you. Does that mean that you don't present your rights? Does that mean you don't tell them that you want them to apply the proper law to your case? No, of course it doesn't. So keep in mind that you're dealing with a lot of frustrated people. You are also dealing, and I mean out there, wherever you're surfing, Google, Facebook, people, your parents you're calling, you're dealing with a lot of frustration, you're dealing with a lot of hurt, a lot of anger, and a lot of desperation. And everybody wants that magic bullet, right? Everybody wants to be able to say, I found the one thing that works every time. If that was the case, none of you would be here right now, or at least not very many of you, right? I mean, there's always those few that are not in touch or didn't hear about something and they find out about it later down the road. I mean, heck, we still have lots and lots of self-help books that have been selling for generations. So what I'm saying is there's lots of different reasons somebody may feel that something doesn't work. And the other thing is a lot of parents, when they come to us, if they're already at the end of their case, which was the case in this particular one, and you're in a final, it's very, very hard to get that turned around, to change the momentum in a final. You're going to have a lot more luck if you start using this earlier on. But again, does that mean that you don't protect your rights and preserve them on the record? I hope not. Because if you don't use them, you're not going to be able to raise that on appeal. You will not be able to challenge that judge. So hopefully nobody in this group has a misunderstanding about what it is we're talking about. We are not guaranteeing that you're going to get your way when you use these methods. We are saying that when you start applying these materials and making different decisions, you will start getting some different results. And most of the time, they're positive results, not always in the court, but sometimes outside the court, sometimes with some of your negotiations with the other parents, sometimes that changes. Sometimes it changes the way you look at things, the way you handle things. And again, in that particular case, where this parent claims the other parent says the material didn't work, we're still applying that material. We're still working with that parent. And there's a lot more to the methods that we use. When we help you integrate this stuff into your life, we also help you change a lot of other things about your life. And again, that's how you deal with that other parent, the kind of decisions you were making regarding the communications with that other parent. So there's a lot of success that we're having in that area as well. So I wouldn't look at that person's situation as it didn't work. And when you start to get negative like that, you are basically closing your own doors. You will cause yourself to fail and not have any other avenue or outlet. So I hope that none of you do that. And if you do, come to me. I'll maybe, I don't want to say kick you around a little bit, but if you kick me around, I'm going to show you if it's accurate, then, I'll say, okay, yeah, maybe that didn't work or this didn't work. But in this particular case, I don't see anything that didn't work. I just see situations where sometimes you don't get a judge that agrees with you. Okay, so if we got that settled, let me go on to our first question. And Steve, you're saying that your ex is wealthy and has succeeded in alienating you from your 4 kids, and the family law system supports her. That sounds familiar. The ex has BPD, which, if any of you are not familiar with that, that's bipolar disorder, and is abusive to the children. Okay, so what is your question, Steve? Okay, so put a question out there. David asked and I'll get back to you when you ask a question. That's the foundation of where he's starting from. So David asked, in trial, how can you get your evidence presented in court? Well, David, I'm glad you asked that question. We are not lawyers, but we do help. Well, what we do is we present information that we read, that we've come across out of some of the law books that we have. So we just share it with you, or some things that we might have done when we were going through it. So I have blog posts, David. If you type in the word evidence on the blog post, it will pull up every article that we've written on that. And in fact, I went into great detail on some of those. So go to the www.fixedfamilycourts.com blog, and I'll post the link up here. And let me get back to the right page. It's quite hot in here. I have a broken air conditioner, so you have to forgive me if I start getting flush. Okay, here's the blog. Go to that page, David, and anyone else, if you want to look at that real quick, because this is a really, really valuable tool. You go to that link, go to the right side of the top of the page where it says Winning Child Custody Strategies. Go below that box. It's a purple box. There's a yellow button that says Opt in to Win. Go below that. You'll see a looking glass and a bar. Type in the word evidence and hit return. Mine's going really slow, and there you go. As soon as you do that, you're going to see posts that say daily tools. Storing and sharing your evidence just got easier. Then go to the next one, entering evidence, hearsay exception. The next one, the 4 steps for entering your evidence. The next one, remedy for removing judicial immunity. Next one, what happens after the final trial, being left in limbo without a final order signed. So, David, let's go to the one that says the 4 steps for entering your evidence. And I'm just going to copy the link for you guys because you can spend your time going through that, David. And then if you have additional questions, you can certainly send those to me through email. So here's the post on that one, David. I hope that gives you what you want. And let's see, make sure I didn't miss any questions up here. Okay. All right. So Steve, you still haven't posted your question. I'm not sure what you're asking on that about your ex has alienated you. You're saying she has a bipolar disorder, abusive to the children. I can tell you that we did discuss some topics regarding, when parents feel that the other parent is abusive to the children and they go in and they try to prove that to the courts, and then the court doesn't do anything about it. I see that happen a lot, and the way that I understand it is, for the most part, I hear about the parent complaining about abuse to the children or making the allegations, lose the children, and then the children end up with a parent that other parent felt or knew was abusive, right? And again, my understanding of it, and from our perspective for what we do, is that from a constitutional perspective, our observation could just be simply biases and they just acted on that. When you're making allegations that someone's abusive to children, from every state I've checked in, child abuse is illegal. It's a crime. So let's say you made those allegations and you did not prove it to that level. And the other parent then counters and starts making claims about you or complaints that you're interfering with their ability to spend time with the children, to have a good relationship, and those kinds of things. And the judge sides with them. They might be using preponderance of the evidence, which is a lowered standard. So it's not right. It's not just at all. It's getting really bad results, which is why we also have posts on that talking about raise the standard, raise the due process that you're using, ask for it in your motion. So when you file a motion to be heard, on your claims, ask for strict scrutiny to be used, ask for clear and convincing evidence, and then make sure that you have evidence to meet that standard, but ask for it to be used so they don't lower it on you. That's what I think is hurting most parents.